Welcome to 775 Alive. I'm Scott Gaborski.
And I'm Crystal Newton. We developed this podcast to talk about the 775, which is rural Nevada, and that in the context of global issues and national issues. So sometimes it can be hard to sort through all that. So we try to break down those things and talk about how it relates directly here. And lately, we have been looking at a lot of, I would call it judicial activism, and a lot of the country's administration sort of being reconfigured through the court system. So we're going to touch on a few of those topics. But most importantly here, we've been looking at that lithium mine. We're so excited about Thacker Pass. The only reason that's moving forward is because of a district court judge decision.
Right.
And I don't know the details of that. What do you remember what happened exactly there?
Yeah, so Thacker Pass, which is up in your neck of the woods there in McDermott, which is on the Nevada-Oregon border there, probably one of the richest lithium deposits in the world right now. This has been a priority for the Biden administration.
Yes. And
part of what was going on is that a coalition of the native tribes in the area, particularly the Fort McDermott Paiute Shoshone tribe, although most of the money came from outside that area.
Interestingly enough,
sued to stop it. And the basis was actually on that there was a massacre, which has been well documented both in native oral traditions and in newspaper press at the time, of a Paiute community by U.S. Cavalry in 1865. So right after Nevada becomes a state. And that this, therefore, becomes a historical incident that would block the formation of the mine. Now, they lost, and there's some interesting stuff. Part of it is they don't know exactly where the massacre actually occurred. And the mine facility is like 1,200 acres or something. So there's a lot of discrepancy on that. It's also interesting from an academic standpoint for me, who works quite a bit with Native groups, is that the court basically said that the Native oral histories weren't accurate enough, which is odd because in this case we had newspaper articles. But I think that what got us sort of talking about this a bit. Oh, go ahead.
How do you make a subjective thing accurate?
What do you mean?
Well, it's accuracy is usually based on logic, and oral tradition would be, I think, primarily subjective.
Oh, I think you're wrong about that.
Really?
Yeah, there's actually been quite a bit of research on starting back in the 1930s about oral histories in like southeastern Europe, and they're incredibly accurate. We'd be surprised at how accurate they are because of the institutions of how they're memorized and how they're passed on. So I don't think that's the issue as much as in this case we actually have printed Western newspaper, at least blurbs, right? It wasn't detailed, but there were blurbs about the thing. So it wasn't just dependent on the oral histories.
Well, do you consider that judicial activism what happened, just ignoring the strong oral narrative in order to permit a green energy supply chain to go forward? Not that I'm complaining. I'm happy that the lithium mine got approved, but we are talking about judges in the district court that are making very influential decisions, and it's seeming more and more like they're politically based.
Right. In this case, I don't think it was necessarily judicial activism, although it does seem to run counter to a lot of jurisprudence that's been slowly developing over the last 15 or 20 years concerning a lot of these native cases. But the activism part, I think, comes into is the fact that despite, I think, what best can be described as an open hostility to any type of extractive industries,
right?
That the Biden administration showed, lithium was the exception.
Yes.
And I think it was quite clear from the beginning the Biden administration was going to be pushing this mine. So if there is that sort of activism, I think it's at that level.
Yeah.
Again, I think it's just the merits of the case were particularly unusual.
Let's talk a little bit about how we got into this mess, because we were talking how do we get to the root of where the judicial system is the one that's really carrying out almost the administration of the country at this point. And you had suggested that maybe it was that third branch of government, the legislative branch, kind of stepping back and not doing their job, that's caused the executive branch and the judicial branch really to come head to head. And we've seen that with the Alien Enemies Act being used to expel illegal immigrants. And then we have the Harvard case, which is combating the cultural issues of the country.
Right.
You're starting to see these things come up. How much of that do you think has to do with Congress not taking a role, making new legislation to address our issues?
Well, and if we go by the Constitution, remember Congress, the legislative branch, is the first branch of government, right? Article 1, right? So it starts right there. No, I think this is an argument that's been going on for a very long time. We've seen this a bit with the executive branch, which is the second. This is Article 2, right? And the executive branch has really been increasingly making decisions, although not just through executive orders in the office of the president, but remember, the bureaucracy is technically under the executive branch. And that's another issue we're going through, which brings us to the judicial. And I think the judicial branch has always been somewhat somewhat the weakest of the three branches as originally constituted. It's great we have them.
Yeah.
Right. But, and people, if you don't look, it's really a unique aspect, right? So France, again, going back to being a French historian, France doesn't have a separate constitutional court system until 1954, right? So it's a very recent innovation in some place like France. So this has really been a unique aspect. And then Marbury versus Madison in 1803, which establishes the concept of judicial review, strengthens the Supreme Court. But in many ways, I think what we've seen is as Congress has become less and less able for whatever reason, and I think there's a lot of reasons, whole separate episode, Congress has not been as effective in passing laws over the past 50, 60 years. And that is increasingly, I think you're right, placed a burden on the executive and the judicial to sort of step into the void.
Yeah.
And I think that's the fight we're seeing now.
Yeah. And I did look at a little bit of the history of nationwide injunctions.
Right.
And so for the entirety of the 1900s, for 100 years, we had 27 nationwide injunctions. And then starting with the Bush administration, you start to see about that many with every administration thereafter. And then by the time you get to Trump 1, we've got 86 injunctions during his administration alone. And so you see this new use of executive orders and the court desperately trying to push back. And they have this fight going, and you kind of wonder, where is Congress in all of this?
Oh, yeah.
And is this strategic or not? But right now we're facing this question of whether one single district judge can create an injunction that has national implications.
Right.
And you pointed out something interesting. There's 9 Supreme Court justices. There really should be 13 because there's 13 regions to this country.
Right.
And I mean, can one of those 13 regions really set precedents for the entire country? And I mean, these are questions that we're faced with right now. The Supreme Court is exactly right now dealing with.
Right. And just heard, oral arguments on the injunction case were May 15th, right? When you say regions, what I was saying was the district courts that have been established by Congress. Of course, the Constitution establishes the Supreme Court and then whatever lower courts Congress seems fit to justify. And there's currently 13 district courts. And total about 700 justices, I think, although I think 43 of the judgeships are currently vacant. And we're just moving in. This is something else that's going to come up here as we're just past about the 125-day mark of the Trump administration.
Is that all?
He's going to start placing these 43 vacancies that exist. Yep. Right.
And in that time frame, he's already incurred 17 injunctions.
But just to complete the thought, what I argued about the Supreme Court justices is that the Supreme Court justices oversee those district courts. And for all the arguments we've been having about potential court packing or issues, I think there is actually a justified argument that maybe instead of having a case where 4 of those districts, 8 of those districts are grouped under, 2 districts, a judge who has to split their time. Maybe it makes sense to slowly ratchet it up. You can't do it all at once.
No.
Right. But you ratchet it up eventually over, 2 to 4 campaign cycles, right? Congresses or something to ratchet it up to those 13 where each Supreme Court justice only has one district court to oversee. I think that's actually something that might be a little bit more serious.
It'll help a little bit, I think. But I mean, you pointed out this, there's only one of them. So this is a single judge making a decision that has nationwide implications, which is probably going to be at the root of what the Supreme Court winds up finding, is that they can't have that much power.
Well, and this wasn't me. This was actually a 5th District Court judge, James Ho, who back in early May gave a weekend interview with James Taranto in the Wall Street Journal. But he makes a very good argument, I think, that if you look at all the other decision makers in government, these district judges, which are, again, established by Congress, right, really are the only government agency that can unilaterally make decisions,
Mhm.
right? And it's not just a matter of national or nationwide injunction. It's any decision they make, right? Congress, you got to work with other members of Congress to get something passed. The
Mhm.
presidency usually has to work, or at least keep an eye on sort of other groups. The Supreme Court, there's 9 of them. You got to work with them, but only the district judges have a unilateral decision-making power in the American system, which is a very interesting argument, I thought, and a problematic one.
Yeah.
Right? And it might be good to go through as a way of discussing this instead of, because these are big abstract
Mhm.
questions. Maybe look at some of these cases.
Yeah.
Right? We'll start with the Alien and Enemies Act. Alien Enemies
Mhm.
Act. We'll get this right sooner or later.
Yeah.
All right, even if the courts don't. So,
And I mean, these things are, it's interesting from the surface level. It looks like there's complete chaos going
Mhm.
on, but I think one of the motivations of Trump is to really challenge all these systems and get the courts to actually make a decision on what is and isn't permissible. Because for so long, the last few decades especially, there's been kind of this finding loopholes and workarounds. And I think throwing all this through the court system is really going to try to help clarify things.
yeah, I think so too, because, and I think,
Especially with the Foreign Enemies Act, it's like, okay, we have all these immigrants come in illegally, and we have no real mechanism to get them out. And the founders really never had a chance to conceptualize that tens of millions of people could come in the space of a few years for largely political reasons.
right.
And we have no mechanism to put them back. And we only have this vague language that ensures a person's
Yeah.
rights. And there's this big conversation playing out right now. What does person constitute? And is that what the founders envisioned? And
Right.
like,
Well, you've got a lot of stuff
yeah,
there.
there's a lot.
There's a lot. So let's unpack some of this. And if I could, let's go back to the Alien Enemies Act and look at that
Mhm.
historically, because I'll argue that it was in 1798. It's actually a package of acts that are known collectively as the Alien and Sedition Acts,
Uh-huh.
and they're actually one of the most consequential set of laws that are passed. This would have been under Adams' administration, John Adams.
And you have to mention the funniest part is like mostly motivated to keep the French Revolution
out. Right. So yeah, I mean, this is the time where the French Revolution is openly embracing this idea of expanding the revolution. You've already had a period
exporting
Exporting
revolution.
it.
Which is a very powerful word there.
Exporting.
Yeah.
You already had a case where there's been a series of controversies where the French are trying to bribe American ambassadors in the XYZ affair. The U.S. at this point is involved in what's sort of known as the quasi-war. It's actually a naval war, a commerce raiding within the Caribbean between the U.S. and France. They're certainly not the only one. The other thing they're worried about is actually British agents working with Indian tribes at the border of the U.S. and shipping stuff in. But it really is the French Revolution that has scared them, like a lot of European countries. So Adams gets these laws passed. One deals with makes it very hard to become a citizen of the U.S.
Mhm.
Right. Another one deals with how the federal government can deport people here illegally. Another one deals, the Enemies Act, which is capturing somebody intending on invasion.
Mhm.
And again, by this point, one of the things they've looked at is that the French have already been involved in an effort of a Irish independence group to invade Ireland.
Yeah.
Not Thomas Wolfe, but the Wolfe Affair.
Yeah.
Right. But then we have also the Sedition Act, which is the one that really causes controversy because it basically prevents open criticism of the American government.
Mhm.
Right. And what happens is Adams actually uses that last one, that Sedition Act, to take out a lot of editors of newspapers that are closely aligned with Thomas Jefferson.
Mhm.
And Jefferson hits the roof, right? Really hits the roof about this, and actually spurs up so much trouble that Kentucky, which is now a state, and Virginia issue these resolutions that basically say that the states, as the originators of the Constitution, can nullify federal laws,
Mhm.
right? And it inspires Jefferson to run for president against Adams, which he does in 1800 and wins, right? And so the real impact of this is not only just the early political history, but that concept of nullification is there's a direct sort of legal chain of thought that runs from nullification here in 1798 and 1799, right to the outbreak of the Civil War.
Yeah.
Right. And it's still a very strong argument in various sectors.
Yeah.
We've seen it a little bit with red states arguing gun laws don't apply, that the states can overrule gun laws, but we're seeing it quite a bit also in blue states on arguments over, cannabis is one, but immigration, right? The whole idea of a sanctuary city is a nullification argument, just like, social slavery had been.
Yeah.
Legally, right? Not making a moral equivalence, but there is a legal argument being made there. Out of those 4 laws, though, the Alien Enemies Act is the only one that doesn't get repealed in Jefferson's administration.
Yep.
Right?
And that's the one we're dealing with today.
And they just, in fact, on May 16th, we just had a Supreme Court rule of decision. The Trump team tried to argue that basically what was going on is that some of these immigrants, particularly ones from Venezuela, where the Venezuelan government released the prisons and helped ship them up here, constituted an enemy invasion.
That's right.
And therefore, the president had direct authority without going through the courts.
Yeah.
Right.
So, what this really comes down to is what the original founders had intended and what this Alien Enemies Act actually addressed. And we look at it as like way back when they couldn't imagine this border situation that we have now. And so we're looking at back then, it was right after the founding of the country, right? You have to get your constitution in place. You've got to get your laws in place. You've got to get states in orders. And then in very short order, they had to address a rush of immigrants trying to take over the country in some way or try to influence it towards one empirical power over the other. So when you look at it from that characteristic, it's what we're dealing with today is outside of the normal course of immigration, right? This is far above and beyond, and this is really a political threat because it was politically stemmed to begin with. So I actually argue, I'm just making a legal argument.
No, I'm following you.
I think it's completely in alignment with the Alien Enemies Act.
Nice.
Just because this is not natural organic immigration. This was politically motivated and enabled in a way we've never seen before. So I think it does fall under that act because it was the same situation that this was made under that we're now facing. And that's my take.
Well, I think part of the problem comes into twofold because it was enabled by whom? I mean, that's question one. So if the Biden administration is the one who invited these immigrants in, the Alien Enemies Act wouldn't necessarily apply. What the Trump administration is arguing is that the participation of the Venezuelan government to specifically force gang members, MS-13, these others into immigration constitutes
an invasion
by a foreign power. And I think that's the key point that needs to be argued. But getting back to the activist judge thing, what's been so interesting about this case is nobody has actually ever discussed these in the lawsuits. We had a judge that issued a nationwide injunction almost immediately. And the problem that gets into here is this is based on one case.
Right.
One single individual goes before a judge, and this gets into the practice of jurisdiction shopping.
One single individual goes in front of one single judge. That's what really makes this
And then the judge issues a nationwide injunction.
Yeah.
And that's been what's problematic about it is that do they have that right? And what was interesting in that Supreme Court decision on May 16th is the Supreme Court actually didn't get into any of the stuff we were just talking about, what constitutes an invasion, which is the legal argument. What they basically said is they kicked this back they let the injunction stand, but kicked it back to the lower court and said, we need to look at the merits on this.
Yeah.
Right? I mean, we're not saying this injunction isn't unjustified, but you can't just say it, right? There's got to be a reasoning here, and we can't really decide on anything until we have that reasoning.
Yeah.
And that has been, I think, a very interesting dimension into this and shows one of the problems we're seeing with these injunctions is that something's getting passed very, very quickly, and nobody's actually discussing about the case.
Yeah.
So, it's a very, very odd dynamic.
It is.
And what's going to have to happen is the court's now going to have to justify that injunction, and then the Supreme Court will rule again.
Yeah.
Right. I don't know where this is going. I will say just briefly, and this is a whole nother topic, that, this might be a very important case going forward as we increasingly deal with non-state actors.
I wonder too how much this was the Supreme Court's way of kicking the can down the road a little bit because it is such a controversial decision.
Well,
the implications are incredible. So I could see him almost clarify, please.
Well,
bring it back because it's like what you said. They really have to articulate the case.
Right. Well, and that's been a criticism of the Roberts Court ever since he became Chief Justice, is that they seem to want to avoid any type of hard decision.
Yeah.
In this case, I think it's interestingly justified because they're doing it in a vacuum without seeing what a lower court might say the merits are.
Yeah.
Now, critics would also say that that just gives the opportunity to the Supreme Court to enforce its own decision, because once they know what the argument is, they'll just find a way around it anyway. I'm not convinced that's going to be the case, but it's an interesting legal argument.
It is. And you also have to, I think this minor impact, but you consider the people that get appointed as Supreme Court justices. Typically, these are people who have not made a lot of controversial decisions. They've been very conservative along the way, and they haven't really ruffled any feathers. I think when I think of some of the more outlandish district court judges, they never quite get picked to be put on the Supreme Court. I think these are some of the most conservative people, and they would naturally want to steer away from more controversial decisions. And I think that's the way they'll always lean.
I'm actually not sure about that historically. No, to take an example, Ruth Bader Ginsburg was involved in a number of very controversial cases as a lawyer and district judge, which is one of the reasons she was put on the Supreme Court.
Was she big on, was it abortion?
Yeah, abortion was one of the big cases.
That is pretty controversial.
But you go even back, Thurgood Marshall had been one of the lawyers in Brown versus Board of Education that starts the overthrowing of a lot of the discrimination against African American laws. He gets put on the Supreme Court. One could argue Earl Warren goes the other way, is conservative as a district judge, but is largely remembered today as one of the more liberal Supreme Court justices, right?
Yeah.
So I think there's actually quite a bit of variation in that. I do think you're absolutely right on Roberts, though. Roberts is an interesting character. It's going to be interesting in 30 years to see what people make of Roberts, because he really does not seem to be interested in rocking the boat too much.
Yeah. Did you hear that story about the word count that came out, and it talked about the word count of each justice, how much they speak during, like, was it Ketanji Brown that she had the most?
They have a huge margin.
Huge margin, and then it was Amy Coney Barrett, she was like 40% of that one, and the rest of the judges were like tiny numbers. They didn't talk, and I think that's really what I'm alluding to, is they tend to be very conservative, and for good reason. You're captaining the ship of a very, very big ship. Our country is huge, so you do want to err on the side of conservatism.
Well, let's get back and look at that in the terms of the injunction issue, because I think you bring up an interesting point. Traditionally, by the time a case gets to the Supreme Court, it's been slowly working through lower courts. That's how the system's designed to work.
Yeah.
And the Supreme Court is not obligated to hear cases unless it has original jurisdiction, right? So like lawsuits between states have to go to the Supreme Court, for instance, under the Constitution. That's its original jurisdiction.
Yeah.
But in a lot of cases that reach the Supreme Court, the justices are already familiar with at least the parameters of the case.
Yeah.
So a lot of the oral arguments, I think, really comes down to just sort of clarifying some issues of thought. What you might be seeing is not something that's going on with the judges as the judges individually. What you might be seeing is that this push towards nationwide injunction is forcing these cases so quickly through the system where there's not a lot of background. And I think one of the things that's forcing is that now the judges have to ask questions because there's not this body of material that already exists. And again, going back to this Alien Enemies Act decision, forcing it back to the lower court for a mayor might be not kicking the can down the road. It might be basically a cry for more information.
Yeah.
Right? How can we even start this? We shouldn't be deciding this at this level.
Yeah.
Right? This should go down lower.
Yeah. That's going to be interesting.
Right.
The other hot button issue is birthright citizenship.
Oh, yeah. Yeah. Trump
run across the border, have a baby?
Yeah.
Is that baby a citizen? Yes, of course it is. But should that be the case?
And I think, and this is going to be an interesting case. And again, right before this Alien Enemies Act came down on May 15th, they heard the oral arguments. Or no, excuse me, I'm wrong about that. The oral arguments issue was about the injunctions on May 15th. The birthright one is still coming up, I think. And
another one of these issues where the founders could never have imagined that people would just come in to have the baby and then have no vested interest in the country. That's a situation that wasn't really thought of at the time that some of these things were thought of.
But it does pop up very early. And let's because this stems from the 14th Amendment, which was designed specifically in 1868 when it gets passed. It's designed specifically to allow free freed slaves, to become U.S. citizens.
Yeah.
Hence the, being born in the U.S.
Yep.
Right.
And then clarified by the Supreme Court when, was it Chinese labor camps in California? Like, do those children have citizenship? I think that was decided by the Supreme Court in 1898.
Yeah. And in between there, you have an interesting case, which actually where this blurs back over into this immigration issue is, of course, you had the 1882 Chinese Exclusion Act, where the U.S. specifically says we're not going to let the Chinese in. But what's interesting is one thing that's often forgotten is even though we're dealing in a time period of steamships and everything, there is this migratory pattern that we see with the Chinese immigrants. We also see with Italians and others coming over.
Yeah.
Right. Where people would come over here for jobs and work for a number of years and then go back to China. And in fact, in the Chinese immigration plan, the assumption was you'd always go back to the Middle Kingdom, as they refer to themselves. Right. You'd always come back. But there's good historical research that a lot of the Italians that come over, by the time we get to the 1890s, early 2000s, they'll come over here and work for a year or two and then go back for 6 or 8 months and then come back. Right. Yeah. So it's just, but in this case, we're talking about U.S. versus Swing or something like that. I can't remember the exact case name. Right. You might have it in your notes somewhere. But in this case, this was after the Chinese Exclusion Act, but this gentleman's parents were legal immigrants. Yeah. Right. They came in before the Chinese Exclusion Act. They had like the equivalent of a green card. They hadn't been naturalized citizens, but they were legal immigrants.
And with a stake in the country.
Yeah. And he was born here. And then he goes to China on a family visit and they won't let him back into the country.
Yeah.
And the Supreme Court basically says, well, his parents are legal immigrants. And therefore he was born here. Therefore he's a naturalized citizen in effect from being born here. And that's what a lot of the critics of the Trump administration's effort to stop birthright citizenship, I think, are trying to point to.
Well, again, we just have never envisioned how it would be exploited. But I'd also like to put that comment in the context that no matter what legal system you set up, there will always be a group of people that try to find loopholes, and that will change how precedents set in the court system. And then another group of people will figure it out. So this is not that the country is over and it didn't work type of a thing, which I think a lot of people get histrionic about these conversations. But I do want to point out that this is a perfectly organic and natural thing to happen within a society, especially a new country. We're only 250 years old. We've got lots of things to work out. And this is part of that system, is we're working stuff out. And it's just Trump's trying to work out a lot at once.
Well,
it looks like everything's going, but it's like, we need to clarify these things.
Well,
can you just run across the border and have a baby and run back? Like, do we want that?
But that is a uniquely American American issue. And again, this is a case where you had one individual goes up again through this jurisdiction shopping.
Yeah.
And you have one individual goes before one judge and a nationwide injunction is issued that says you can't move against this. Yeah. And it's, again, it's a very complex case, because the counter argument that a lot of people gave is, again, first of all, in the main Supreme Court decision, the parents were legal immigrants, right? So that changes the dynamic quite a bit.
It does. But it should.
It should. Oh, no, I agree as well.
You have a stake in this country? Absolutely. I just have a problem with people with no stake in it, because I'm like, what's to keep you following our laws and keeping the best interest of our country? You need to have a stake in it.
I'm laughing because we were chatting as we were doing a thing about this. Is there's actually an interesting case. One of the things that's similar to this is that the president has to be a natural born U.S. citizen.
Oh yeah.
And people are like, why do we have that? Why can't Schwarzenegger be president? Right. But I brought up the case back in the 90s in Peru, where they had a person of Japanese descent that became the president of Peru and held dual citizenship.
That's wild that happened.
And basically, this president got involved in a lot of corruption. Flees to Japan, and Japan refuses to extradite him back to Peru because he's a Japanese citizen. Yeah. So, even here in the 1990s, within 30 years, there's been some cases where these issues have come across. But more importantly, diplomats don't automatically become U.S. citizens. Persons under jurisdiction of foreign countries, right? So visiting military officers or people who are tourists who don't make the decision to come to the U.S. to stay permanently have no expectation, even if their child is born here, right? Or it don't seem to have the expectation, right? Now, technically, the children of tourists that are born here, I guess, will become citizens for being born here. But I don't know if anybody has picked up on that.
I don't know if you know the answer to this question, but it would be interesting. I didn't do any research on how this issue is tackled with other countries that are similar to us, like Britain, Spain.
Oh,
Canada.
birthright citizenship is almost unique to the U.S.
It's just unique to us.
Yeah, there might be a
what's the
handful.
Process there.
Oh, you have to go through naturalization.
Okay.
You have to become a citizen.
So unless your parents are citizens of that country,
right?
If you're born there, you're not necessarily becoming a citizen.
Right now.
So do you feel like we need to move in alignment with? I mean, I feel like that's a pretty good standard, but there's a route. If there's a route to go, if that's not the case, so if you are born in foreign soil and you want to become naturalized, there is a route. So it doesn't exclude people. But I do like that, like both parents are citizens, then automatic citizenship makes sense. But if they're not, we probably have to show us a few things.
Yeah, we probably have to do a whole episode on that. I'll just say that I'm in favor of immigration through naturalization of citizenship, because I think it solves far more problems. I think it's far more protective of immigrants.
Yeah,
this is one of the problems. A lot of these illegal immigrants are being exploited.
Yeah.
And it's not just the gangs, it's not just the coyotes bringing them across the border. It's not even just businesses, it's landlords, it's everybody else that are exploiting these people.
Yeah.
And that exploitation is mitigated strongly in a legal immigration system. Yeah. So whatever we think about the politics side of it, there's some real benefits to legal immigration that tends to be ignored.
And it's a little bit revealing for like trying to see things from the liberal or democratic standpoint. I mean, they've gone, in my opinion, way too far in trying to protect illegal immigrants, but there is that basic issue. If we don't protect them, they will be exploited. And we were talking a little bit about that earlier, like I think it was Atlanta, where almost all the construction crews are Latino. And one of the advantages for those employers, if they get hurt or not following the rules, they won't complain.
Right.
And that's an example of where we really do need to have some protections in place and some way of
that's another
dealing with that. It's and it's really, I'm not trying to be a bleeding heart for immigrants, but it's just, when stuff like that takes place in your culture, it doesn't stay contained.
No.
And attitudes they change because that stuff is being permitted, and it's just not good for the overall society.
No. Well, and this gets back to the injunction issue, though, because a lot of the injunction issue is argued on these moral arguments about what's best for society. The question is, do these district judges have the right to make that decision for the country, or should there be a southern mechanism? And I guess we might as well just do it, because May 15th was the injunction argument right before the Supreme Court. Which is interesting because, we've been looking at this from the perspective of a single individual case goes before a single district judge, and the district judge doesn't make a ruling just for that case or that district, but for the country as a whole.
Yeah.
And this is what the Trump administration has targeted in this case.
Yeah.
Right. Specifically. And what's interesting to me, and I want to go back to so many of these, you said something earlier about so many of these changes coming up with the Trump administration trying to get all this solved. I think this is actually one
clarification. Maybe not solving problems, but let's get some clarification on how the judicial system can work, how the executive branch can work. Let's get clarification.
Right. And I think the oral arguments presented on May 15th, I think, is a good argument that's really what the Trump administration is aiming at. Because even though they made an argument that these district judges can't issue universal injunctions, they do allow one possible exemption. This is the Trump team arguing that possible exemption might be if you have a class action suit that brings in people from across the country. And the very fact that they bring up the possibility of an exemption based this way, I think shows that the Trump team is actually seeking a clarification, because they're altering, we realize this might not be a case where it's all or nothing.
Yeah.
That there might be some middle ground here, and they're signaling up front we're willing to accept that middle ground. What it would do, though, an example I was thinking earlier is that, a lot of people are like, well, illegal immigrants or undocumented immigrants are a class. Right. Therefore, this would apply to.
That's what I argued earlier.
That's what you.
They are a class nationwide.
But it changes the perspective. So first of all,
more than one of them have to be in the lawsuit itself, not just one of them.
Which blunts the ability to jurisdiction shop, I think.
Yeah, and I think we really need to hold on to that sliver as much as we can, because there's the legal basis that they have to make a decision on, and it may not go in our favor. But there's a fundamental issue of what's going on here. 100 years ago. if a district judge made a decision, it was kind of confined regionally. It would take a while to work through the system and really establish precedents. Today, a judge can make a decision in the next 5 minutes. It's on national news and everybody's hearing about it. And other judges could start to take that track. And while there's nothing wrong with that, because eventually if there's a problem with it, it goes to the Supreme Court makes a decision, and then everyone follows from there. Well, the problem is right now that that district judge can make that decision, and that's going to stand until the Supreme Court gets around to it. And so it becomes a disaster for us as a society to try to run a country if, in fact, a district court judge can set national policy and not get checked for a couple of years while it works its way up through to the Supreme Court. So there's a very serious issue there if they don't mute these district judges in some way.
I agree with you, but I actually don't.
I know that sounded really undemocratic. I
No,
should probably
no,
use
no.
a different word than mute. Like
No,
should
no.
restrain their power. And
Well, I'm not sure restraining is. Yeah.
Okay.
But-
Shut up and let Scott talk.
No. Don't shut up, because it is an interesting point. I think
it's a real problem.
right, but I don't think it's the speed of communication. I think what it reflects is a different issue, which is that there is a growing understanding of the centralization of power in the country.
Yes.
Right. And I think why you didn't see this 100 years ago was not because it was a slower process. I think that most district judges were only hearing cases that really only impacted their region and didn't have the conception this is something that's happening nationwide and we need to stop.
Yeah.
I think that's the change that's gone on. But the main point is right, that they're probably, again, that's why I like that James Ho interview, right? I mean, Judge Ho makes a very compelling point that, these district judges are unique in their capacity to unilaterally make decisions that we don't find in other branches of the U.S. government, even the presidency.
Well, and we've recently I recently discovered the, Democratic targeting of district attorneys' offices. And I mean, that really didn't make sense to me as a political strategy to go after winning district attorneys' offices, but that gives them a lot of power too, because you set those rulings and those precedences. And I've just kind of watched them figure out ways to use, and it's both sides, I should say.
Right.
I'm just watching this judicial system kind of get intertwined with the political system. I'm not even sure the judges like it themselves, but they're stuck in it.
Well,
they're like, can we just go back to not being paid attention to?
They're not necessarily stuck in it, because theoretically, these judges in these cases could say, okay, I'm not going to let you deport this one person under the Enemy Alien Act, right? But I can't touch what's going on in the rest of the country. So they are capable of not on this. But and you're absolutely right. This is not just the Democrats targeting doing this jurisdictional shopping. In fact, they claim the Republicans did this against Biden, because there were a number of Biden injunctions as well.
It's just taken me a while to catch on to the fact that the parties were figuring out ways to weaponize the judicial system. And that's why I make the comment. The judge is not necessarily wanting to participate in it, but they're kind of stuck now, because if one makes this radical decision and then all of a sudden this other one does, like, what do you make as I mean, if you don't see eye to eye with that, it's like it can start to get wonky as far as precedents.
Well, we've already seen some cases of that. What you have is two district judges can make different decisions.
And if it's conflicting nationwide, what happens in that situation? I think that proves that they don't have the power.
No, well, I don't know if it proves they don't have the power, but what it does is it fast tracks it to the Supreme Court to make a decision.
Yeah.
But
you had said 700 district judges.
Yeah, a little under 700. So what's 630 plus 43? 673. So almost 700.
We're not math people.
We're not math people.
I'm glad you were able to pull that one out. No, but the idea that maybe out of 700 judges, you'd have one make a ruling that's in complete opposition to another ruling kind of shows you that no one judge really has that platform to make a nationwide statement. Right. Because it's like, well, someone else could make the opposing one the next day, and then what?
Right.
Like, this is ridiculous.
Well, and this gets back to the point you as I've been boring you with this argument, that the real problem is that why are laws being set at the judiciary to begin with?
Yeah.
Right. Why isn't Congress?
Yeah. Who is supposed to set the laws?
Well, it should be Congress. And we have that on immigration issue. But again, we have a Congress that, and I've pointed out, I've been a big fan of Schlesinger's imperial presidency thing, that Congress has been giving more and more power to the presidents over the last 60, 70 years. And a key part of that has been, again, a lot of Biden's actions on the refugee comes from Carter I think it was Carter era, is a 1970s law that gives the president the power to designate refugees, right, who can come in, and we're seeing that now with Trump and the South African farmers, right? Well, whereas shouldn't Congress be setting that power?
Well, the South African issue really, that blew up in a way I wouldn't think it did.
Well, that's
Holy cow.
That's been an issue that's been festering, and there's a lot of deep moral conundrums with that. But it does illustrate, and again, I think this is, I hate to say it, but this is a case where I think the Trump administration is engaged in a bit of trolling.
Yeah.
Right. Why is it okay to say, somebody who is living under a threat of gang violence in El Salvador is a refugee, but somebody that is targeted by government violence in South Africa, not.
I see.
You're right. And this is and this is an issue that goes much deeper than this activism, but it is an interesting dimension to this over, because the fundamental problem we're stuck in is who should be making laws. We have a constitution that seems on the surface very clean cut, but we've got a series of practices that have become very muddled.
Right. And like I said, this is true for thousands of years. Like any people that make their way into power, they'll figure out a way to rig the system. There's just no way to think of everything when you write your articles of incorporation or any kind of constitution. Eventually, people are going to figure out a way to game the system, and then you've got to go and correct it. And then another group. Guess what? If we solved everything under Trump during this administration, I give us 20 years, we'll have a whole new set of challenges. Because people always try to find a way to get ahead.
Right.
And there's millions and millions of people scheming against this one document. They'll figure it out. And we just that's just something we got to deal with. It's never going to end, but we're going to try to curb it back a little. It's like we're massive weeding right now. Like, it's trying to get ahead of it.
Well, and it might be an interesting look. Is it really scheming, or is it trying to avoid what a lot of scholars, Lovin comes to mind, but, Lovin, comes to mind, that the Constitution's made to force compromise. That the only way to get stuff done is to work with other people, which, again, these district judges we've been talking about don't have that. There's nothing that forces them to work with this, and that might be the ultimate problem. Is we have this anomalous sort of section of the judiciary that's now involved into not being subject to the compromise provisions of the Constitution, which is an interesting way to think about this.
Yeah. So, we'll see how it all shapes out.
So I do think we ought to come back and do a whole separate episode on immigration. That might be fun to talk about. So we'll with that.
And as pressing as these things are, I do want to hit home that it's not worth tearing your hair out and stressing out about. This is just a product of human beings.
Right. So, you give us some comments and questions. You can reach us at info@775alive.com. Follow us on social media. I'm Scott Gaborski.
I'm Crystal Newton.
And we'll see you around the 775.